Good morning, everyone. Can you all hear me quite clearly? Yeah. My name's Tim Spencer-Lane. I'm a lawyer at the Law Commission. I'm responsible for our review of health and social care professional regulation. And I've come here with my colleague Justin Leslie, who is the research assistant for the project. What we want to do today is just talk you through some of our key proposals. We've highlighted some areas that we think you would be particularly interested in, and maybe get your views on what we're saying in our consultation paper, and maybe have a debate with you about some of the issues we raise. We have done a number of consultation events already with a wide range of different individuals and organisations. So what we want to tell you as well is some of the emerging themes that are coming up as a result of consultation, because as I'll go on to say in a moment, consultation is very important to the Law Commission, and we are genuinely very interested in your views. So I'm going to start off with the boring bits about who the Law Commission is and what we're about. First of all, we are an independent agency established by statute law, the Law Commissions Act of 1965, which vests the duty on the Law Commission to keep under review all of the law of England and Wales. And although we don't have powers to introduce legislation, we can instigate reform of the law, and many of our reports do eventually become government-sponsored bills. Recent examples include the Mental Capacity Act, for example, which was based on a Law Commission report. We also made proposals in relation to adult social care, which we hope to be on the statute book in the next 2 years. And there's some very clever person at the Law Commission who's worked out that, on average, about 2/3 of our final recommendations make it into statute law in one form or another. So we do have a good track record of instigating reform of the law. In terms of this project, it came to us as a result of a reference from Andrew Lansley in 2010 in the Enabling Excellence White Paper. And the very strict remit of the review is, first of all, to review the UK law relating to the regulation of healthcare professionals, and in England only, the law relating to the regulation of social workers, to take into account the new remit of the Health Professions Council. But in the main, our review is about healthcare professionals in England, Wales, Scotland and Northern Ireland. As I've mentioned, the proposal for a review was sponsored by the Department of Health, so they're the lead department for the purposes of the review. But it's also supported by the devolved administrations in Scotland, Northern Ireland and Wales as well. And the review, the consultation paper, does have a strong flavour of devolution about it and all the problems that arise as a result. And we're quite proud to say that this is the first Law Commission project, which is a joint project with our colleagues in Scotland and Northern Ireland, which does throw up a lot of logistical problems about getting various things approved, but it nonetheless reinforces the fact that healthcare regulation is of UK-wide extent. It's not it's not something that's England and Wales only. In terms of the timetable for the project, the consultation paper itself was published on the 1st of March. We have the normal 3-month period of consultation where we're going up and down the various countries, meeting stakeholders and listening to views. Consultation ends at the end of May, 31st of May. Our timetable after that is that we are tasked with producing our final report, which will be laid in Parliament in early 2014, which will be about February 2014. And the government has committed to trying to seek a slot in the parliamentary timetable in the last session of this Parliament. So the intention is that we produce a final report. Attached to that final report will be a draft bill. The government then has the option to take that draft bill in its entirety and put it through Parliament if it wishes to do so. Or it may decide to take other options like further consultation on the draft bill, but that will be an option for the government to decide. This slide is a sort of visual representation of the absolute mess that is professional regulation, the legal framework for professional regulation at the moment. The general structure is that each profession or various groups of professionals are covered by separate statutes, single statutes. So there are at least 9 of them at the moment, which sometimes cut across each other, sometimes they're inconsistent, and it throws up a lot of problems for the legal framework for professional regulation. The problems include that the legislative landscape is complicated. They include that some of the fundamental aspects of professional regulation are inconsistent across the regulators. For example, the definition of a vulnerable adult, a vulnerable witness for the purposes of fitness to practice hearings differs across the different regulators. Another problem is that each of the regulators have different powers to undertake the task of regulation. So, for example, some regulators can establish screening systems to try and sift out some allegations which they don't think are serious enough to take forward. Other regulators have to take it forward any allegation to a formal committee hearing because they're required to by their statute. So one of our aims is to try and even the playing field in this respect, to give regulators equal powers to undertake the task of regulation, although not necessarily to tell them how to undertake that task, but just give them the same menu of options. The other problem we've identified with the existing legal framework is that it is very expensive to run, not just for the regulators themselves, because there's an inherent amount of delay built in, but also for government, that every single rule change needs to be run past the government, who then has to go through Parliament in order to change rules, to introduce innovations. And the Department of Health has a very big legal team that has to assist in things like drafting rules. The Department of Health have made it very clear to us that they want out of professional regulation, and they want increased powers to be given back to the regulators to undertake the task of regulation. And in part, that's one of the reasons for the proposals that I'm about to describe. So that's the background to our review. Before we go on to look at some of the detailed proposals, I do want to just make one point which I alluded to at the beginning, which is that the Law Commission does take consultation very seriously indeed. We're not like the government where we've made up our mind, we go off to consultation and then go ahead and do what we're going to do anyway. We will be reviewing every single proposal, and I warn you, there are a lot of proposals in this consultation document, but every single one of them we expect to change as a result of the views made known to us at consultation. And any of you that have seen our previous consultations on the Capacity Act or adult social care will know that our proposals in those areas change radically as a result of consultations. So these are what they say on the tin. They are provisional proposals for the reform of the law. Some will get through, others will be revised. So we are very interested in your views. Before I go on, I'm going to pause slightly. Are there any questions that anyone wants to ask about the review itself, or the timetable, or any of the sort of mechanics of our review? No? Okay, that's fine. Let me get on then and to talk about some of the basics. So firstly, first of all, the structure of reform, how the new legal framework would allow for the regulators to undertake the task of regulation. Our basic starting point is that there should be a single UK statute which would cover all of the healthcare professionals in the UK. So going back to that slide, all that legislation would go in its entirety. So the nursing midwifery order, for example, would be repealed and replaced by a single statute covering doctors, nurses, midwives, dentists, social workers, etc. There would no longer be this maze of different legislation. Secondly, our basic premise is that there would be broad powers for the regulators to undertake the task of regulation, that there shouldn't be any needless restrictions on their ability to regulate, with some exceptions where we think the statute needs to establish consistency across the regulators. Nonetheless, we see this as being a high-level statute which would consist of a number of enabling powers to authorise the regulators to do various things but not require them to do so. And the reason for that is that we don't see that it's possible to impose a one-size-fits-all approach to all of the different regulators, because we think that the regulators need to take into account the particular context in which regulation is delivered, i.e. the needs of the professionals that it regulates. Thirdly, the existing role of the Privy Council, i.e. the Department of Health, we think the Privy Council's role in approving rules and regulations is just a fig leaf. It's really the Department of Health who do all the work here. We think that that should be removed in its entirety. Instead, the regulators themselves will be able to issue rules and regulations or amend their rules and regulations. Now, in order to do that, they would be required by the new statute to undertake detailed consultation. They would be required to justify its changes, but they wouldn't have to be laid in Parliament anymore. The reason being that that seems to build in a good deal of delay into the system, often as long as 2 years. So we're trying to allow the regulators to innovate and introduce new systems of regulation if they see fit. Nonetheless, we do think there are some areas which can't be left to the regulators because they're too important in terms of the public interest or in terms of public finances. So we've tried to identify certain areas where we think that either the statute should specify certain things or that these decisions should be left to government. And to give you a very obvious example, any proposal to bring in new groups of professionals into professional regulation, we think should be a matter for government to decide through a regulation-making power, rather than leaving that decision down to the regulators to make on their own. And there are a number of other issues that we've highlighted in the consultation paper, which we'll be running through today, where we've also made that call. Again, in consultation, we've had mixed views on this. A lot of people have felt that on certain issues, we haven't made that call correctly, and that some things should be left to the regulators and more things should be left to the government, for example. We'll be very interested to hear your views on the issues that we've identified. Finally, we've looked into the issue of parliamentary accountability. At the moment, the regulators have been called before the Health Select Committee, or at least the GMC and the NMC have been called before the committee. We don't think that that's a major form of accountability, but nonetheless, we think it is important to retain that link. I mean, ideally, we would like to go ahead and propose a joint committee of both houses to scrutinise the work of the regulators. But Parliament is also under the same sort of resource constraints that the rest of us are under at the moment, and hasn't shown a lot of interest in taking that particular recommendation forward. But we think at the very minimum, the Health Select Committee should have a role in holding the regulators to account. Now, in terms of the feedback we've had on the structure of reform at the moment, a lot of people have said to us that they think that this is a very good deal for the regulators, that they've been given a lot more freedom and that their levels of scrutiny arguably have gone down as a result. So we've been quite interested in that view. If we did want to enhance the accountability of the regulators, one of the key organisations that might be able to do that, arguably, is CHRE. Now, if people do want greater scrutiny of the regulators, then an enhanced role for CHRE does become very attractive, because they're the ideal body in terms of where they're placed. But that does bring problems. CHRE at the moment aren't equipped to undertake that sort of rigorous role. They've only got between 20 and 30 members of staff. That would have to be increased quite significantly. And who's going to be paying for that in the future? Well, under the Health and Social Care Act, it's going to be the regulators themselves who pay for CHRE, i.e. it'll be the registrants who fund it by default. So it'll be nurses and midwives, for example, who would be funding that sort of enhanced level of scrutiny. So although CHRE may well be attractive, there are nevertheless problems for that enhanced role. The other element of the structure of our statute is what we've called a single paramount duty for all of the regulators, i.e. a single duty that when the regulator is undertaking its functions that it must have regard to. So we think that there should be a single duty in the statute which would apply to all of the regulators as well as CHRE. And our current formulation of that duty I've put up on this slide, and it's basically a sort of public protection kind of duty, saying that the paramount duty of the regulators is to protect, promote and maintain the health, safety and well-being of the public by ensuring proper standards for safe and effective practice. More or less what a lot of the existing legislation says anyway. Nonetheless, even though that's very much focused on public protection, case law is also very clear that the regulators do and can intervene in cases which involve maintaining confidence in the profession. What we've been struck by is firstly that the legislation itself doesn't mention maintaining confidence in the profession, but also that the relationship between maintaining confidence in the profession and public protection is often a bit muddled in the case law. It's not quite clear how far the regulators can go in maintaining confidence in the profession, even if there are no public protection issues involved. So, for example, if a professional were caught on a speed camera speeding and got their ex-wife to take the fine on their behalf, I don't know where that example came from, should the regulators be able to intervene in that case against the professional? Arguably there are no public protection issues, arguing there are no public protections issues, although I'm sure some smart aleck lawyer could probably link it. This seems to us to be mainly an issue about maintaining confidence in the profession. Should the regulators be able to intervene in those sorts of cases? Now, if the answer to that is yes, and at consultation we haven't had a clear consensus about this, but for argument's sake, if the answer is that the regulators should be able to intervene in those sorts of cases, then should the statute make that clear, i.e. that the paramount duty of the regulator is to protect the public and maintain confidence in the profession. So again, we'd be interested in hearing your views on that.